in the materials. Another interesting spin on surveillance and or videotape is in Christoph versus Glasson. That was a unique twist in that case. Plaintiff's attorney, it's a car crash case, line of sight issue. Plaintiff's attorney hires a videographer to go to the scene of the incident, and they videotape, but the attorney says, hey, I don't want any audio on this videotape. Apparently the videographer forgot he had the audio running. And opposing counsel apparently believed that they were entitled to that audio portion of the videotape. Now the court ruled that the audio portion was protected from disclosure because it was a tangible item prepared in anticipation of litigation and was therefore work product. But the court went further, and it said the substantial need and undue hardship elements were not satisfied as opposing counsel had the opportunity to question the videographer. And further, the plaintiff's attorney had not given the videographer any specific instructions as to what to do or how to do it with respect to operation of the camera. So I guess what we learned from that case is make sure the audio is turned off and don't ever say anything when the videotape is turned on. Further, the video was for demonstrative purposes of depicting the accident scene. It was not so unique as the defense counsel could have prepared the same videotape had they desired. And finally, the Court of Appeals recognized that the audio portion of the videotape would likely be privileged, subject to counsel's mental impressions, conclusions, opinions, or legal theories. A couple other cases I just want to touch on very quickly. Post-trial video surveillance. Apparently, case went to trial, plaintiff's verdict. Plaintiff miraculously healed after the verdict was rendered in favor of the plaintiff. Defense counsel hired video surveillance, which showed the plaintiff doing the things the plaintiff said that they could not do. The case is Hawkins versus Cannon, but the holding in that case is basically that surveillance, which could have been done before trial, and the court made specific reference, 2 years and 8 months, they could have done this but failed to do so, was insufficient to justify a motion to correct error to overturn the jury verdict. Now, videos prepared for mediation. I saw the string. I talked to Mike Valentine on the issue of whether or not when we do these day-in-the-life videos, you hire Dave Fulton, Image Resources, or somebody else to do that. Can the defense, in fact, get the raw footage? R.R. Donnelly and Sons versus North Texas Steel, it's not a personal injury case, but it's interesting because if you prepare the video solely for settlement negotiations, it is protected and its production is not allowed because it would have a, quote, chilling effect on settlement negotiations and therefore is not admissible, end quote. If they ever try to get the raw footage, you just have to fight it. And I would cite R.R. Donnelly and Sons as the leading case on that proposition. Now, there's really two types of video.